Good morning, this is John Lynch of Lynch Solicitors in Clonmel, County Tipperary. I'd like to do another of our COVID-19 series, and this time it's about medical negligence. Actually, you could broaden that out and call it professional negligence, because it's not just, the principles are not limited simply to medical negligence cases. This was the subject matter of a relatively recent Supreme Court judgment in the Morrissey case, which was handed down in March of this year. The Morrissey judgment, I think we might all be familiar with, in that it was to do with the cervical cancer case and the reading of the scans. In the High Court, the judge decided that there was liability on the part of the people who were carrying out the scans, insofar as he made a factual determination that they had not, in fact, correctly read the scans or complied with the requirements to read the scans. This was not the case in the Feeney judgment, which was delivered in May of this year, where the High Court decided and made the opposite determination and decided that, in fact, there was no negligence based on the facts. This highlights what Clerk CJ in the Supreme Court case was saying, where he said that when you're dealing in medical negligence, obviously each case must be decided on its own facts, that it's a matter for the court to look at the evidence and make the decision whether or not there is negligence. He started by saying making the broad principle statement that just because somebody gets cancer and just because there was a prior scan and that scan didn't pick up the fact that there was a risk of cancer, that in those circumstances that does not lead to the inevitable conclusion that there is negligence. He pointed out, or I was going to say reiterated, but he made the point that each case is a factual exercise by the court. Not a surprising principle, in that it's the cornerstone of almost any case, is that you have to prove your case beyond a reasonable doubt, and you must have the evidence to prove it. The interesting observations or comparisons between the two cases was that in the Feeney case, the judge, having assessed all the evidence, decided that the expert evidence wasn't persuasive by the plaintiff, and that in those circumstances she found against the plaintiff. The opposite was the case in the Morrissey decision, where the judge decided that the evidence was in favour of the plaintiff, and he made a finding of negligence, which wasn't overturned by the Supreme Court. The second side to the whole analysis, if you like, is the question of what exactly is medical negligence. And again, the Supreme Court case actually went back to first principles and suggested that, in fact, the test was no different in medical negligence cases than it had been for the last considerable number of years. And he applied what was called the Dunn Principles, which are long, well-established legal criteria for establishing medical negligence. And to paraphrase it, he basically said that the test is the same as it always has been, i.e. that you compare the factual circumstances and you look at them on the basis that, with the question in mind, would a professional of similar standing and experience make the same decision? And if that is the case, in other words, if they go with established practice, that as a basic principle means that there should be no liability. Now, there are exceptions to that, but he said that the principles are still basically the same. He calls these he uses the term countervailing or whatever. The Supreme Court decided in the Morrissey judgment was that the starting point in any professional negligence case requires the identification of the standard of approach which would have been applied by a professional of the appropriate standing or skill as the person against whom the allegation of negligence is made. Accepted practice is highly relevant, although departure from the normal practice may give rise to negligence. That's basically highlighting the fact that you can have differences of opinion, or you can have somebody who doesn't follow the standard but yet is not negligent, or you can have somebody who follows the standard but because the standard has a latent defect in it or an obvious defect in it as opposed to latent, that there could still be liability. So that basically is reiterating the Dunn Principles, and therefore the Supreme Court says that the position hasn't changed. He also highlighted that this is the case for all kinds of professional negligence and not just simply the case at hand, i.e. misdiagnosis or non-diagnosis or failing to diagnose as opposed to other cases like such treatment cases. But he talks about this as the overarching principle, i.e. the whole standard of approach test, which, by the way, he moves away from standard of care and just talks about standard of approach, but effectively that's just to avoid the confusion when you're dealing with medical negligence cases, where standard of care might be in the mind of the person listening to the principle that of kind of medical care as opposed to care as in the approach they take to the care that they apply. But anyway, that might be overly complicating it. So basically, after the Morrissey judgment, you're left with the same test as we've always had, and that is the accepted practice test. And when you look at the accepted practice test and look at how it's applied, there was a lot of talk about the whole issue of expert evidence. And I suppose the case highlights both cases, actually, both the Feeney case and the Morrissey case, highlight how important it is and the relevance that the courts attach to expert testimony. Because as the Morrissey case highlights, the expert is there, first of all, to give a view as to what is the proper standard to be applied. And that's the standard of approach we're talking about. And the expert may also be there to give an opinion after the fact as to how the act of negligence arose. So, to put it in simple terms, you might have an engineer in, let's say, an accident work case who would give two types of expert evidence. One would be evidence as to what the correct engineering standards were, and the second part of his evidence might be, or her evidence might be, to apply those standards to the facts of the particular case and offer an opinion as to whether the accident actually happened the way that the person taking the case suggests it happened. But that, I think, just simply highlights the importance of expert evidence and expert witnesses in medical negligence cases. And I think, just on a closing point, the importance of it is very much highlighted in the Feeney case, where the judge actually, on looking at the evidence of the plaintiff, was not satisfied that that evidence was sufficient to prove the plaintiff's case. However, in the case of Morrissey, it was the opposite. The judge was satisfied that the evidence was sufficient to prove the plaintiff's case. So, in conclusion, I think, just as a kind of an add-on to this, it was interesting that the Supreme Court reversed the High Court in terms of the compensation given in the High Court to the husband for, inverted commas, loss of services as a result of the cancer misdiagnosis. And the Supreme Court was very reluctant to make and to allow that particular claim. And the final point that's of interest in the Morrissey case is the fact that the court had no difficulty in accepting that the HSE was liable even though they weren't directly involved in the act of negligence. They were liable insofar as they were, if you like, responsible for the overall scheme, and therefore the had a vicarious liability. The term vicarious liability meaning even though they weren't liable themselves, they were liable because they were involved in a way with the whole for all scheme, similar to an employer whose employee carries out some act of negligence makes the employer liable. So it's a secondary liability. So thank you again for listening to me. This is John Lynch of Lynch Solicitors with another one of our COVID-19 videos.